Right, you are welcome to this video. My name is Lucky O Ledose, PhD BL. I'm a legal practitioner called to the Nigeria Bar by the body of benchers. Today, I'll be taking a look at thoughts and medical practice. And it is a part of this very book that you are seeing on the screen. If you are interested, you can request for a copy. It's titled Medical Law and Forensic Medicine in a nutshell, from clinic to courtroom, and it's also annexed with the National Health Act 2014, the Nigeria National Health Act. Now, in the first place, you might ask yourself, what is thought? Normally, thought is not as in the normal literary meaning of the word thought, which is THOUGTH. But this is a legal concept which has to do with a legal wrong against a person. And in this very lecture, we are averting our mind to medical practice. Now, the law of tort deals with civil wrongs, like I said before, and usually it arises from breach of duty or failure to exercise care that is required of a person who owes a duty of care to another person. Now, breach may occur within or outside contractual relationship. But you know that the issue of care, provision of care to a patient, is a kind of contract having its own kind of elements different from the general contract because of what is involved in providing care to patients and the nature of medical and health care that somebody will seek. But that is a subject or topic for discussion for another day. Now, when we say tort, breach may occur within or outside contractual relationship, like I said. And the objective of bringing an action against an erring medical practitioner is to ensure that compensation is paid to the victim that suffered a harm. Now, tort and medical practice in Nigeria, I think, like in other jurisdictions all over the world, the issue of tort in medical practice we center around two components, which are trespass to person and negligence. And these are the main elements or components that determine whether a person is to be held liable or not. A medical practitioner can be liable for trespass to the person, just like when you trespass, when you have a trespass to land that belong to somebody else. It means that you have an authorized entry to that land. It is the same way in medical parlance. When you say trespass to person, it means that you have a contact with the body of that person without consent or agreement of the person that you have had body contact with. Now, the second component of tort in medical practice is negligence. Negligence simply means that the person to whom you owe duty of care, you fail to exercise the reasonable level of skill and knowledge or expertise that is required to attend to such person. In that case, you'll be held liable for negligence. And these two components of trespass to person and negligence, like I said before, actually determine whether a medical practitioner is liable in law or he or she is not liable in law to the patients. Now, like I explained, trespass to person in medical parlance can be a form of insult, which is creation of fear of imminent unlawful contact. So this is very uh, clear in the sense that when we say assault, it means that you have not had impact with the body of the person, but you have made an attempt or you have demonstrated some overt acts, which of course has put the person in an imminent fear that you may likely have a contact with his or her body, a contact that will normally result in harm, so to speak. Now, the other element of trespass to person that could be committed by a medical professional. When I say medical professional, I'm not just saying doctors alone. It covers whether doctors, nurses, medical scientists, those who are involved in the provision of healthcare. Now, the other variant is battery. Battery is the actual unlawful contact with the body of the patient. Now, this was illustrated in the case of Undibe against Undebe, where the dispute involved unlawful physical interference with another person's body. In that case, the court considered whether the defendant's action created fear of imminent harm and resulted in actual physical contacts. So what we are saying here is that when it is a case of trespass, when it is assault, it means that you have made a menacing attempt or advancement towards the person you want to have contact with, but you do not actually have physical contact with the body of that person. For example, in medical practice, you may have said, okay, if a surgeon holding a scalpel is advancing towards to, cut open the part of the patient body, but he has not actually, committed the or carry out the conduct or the contacts. That is an assault. But where he has actually have an impact with the body of the patient, of course, it becomes a battery. But I must be quick to say that assault and battery, in most cases, they go together because assault comes first, followed by battery. This was the illustration in the case of Undibe against Undibe. This case clarified the decision between assault and battery, and both of them are actionable thoughts. Now, a consent in medical practice. Consent makes physical contact unlawful or make it lawful. Where the consent is not given and there is a contact with the body of the patient, then it becomes what? Unlawful. But if the consent is given, it becomes what? Lawful. For consent to be lawful, certain element must be present and the medical practitioner must take cognizance of that. Consent must be freely given. If consent is not freely given, then it is equivalent of no consent was given. Then consent must not be obtained by force or by deception. You see, if you say the person has given consent and you have played some pranks on the person before he gives that consent, then the consent given can be obtained and you will be held to be liable for commission of torts. Now, this legal principle is found in the case of Dr. Okekearu against Danjuma Tanko. The disputes arose from a medical procedure carried out without proper consent. So when we say consent is not proper, just like what I said, if it is given out of dissection, if it is given not out of free will, if it is given out of duress, then such consent is not a proper consent. Now, what the court examined in the case of Dr. Kikaro against Danjuma Tako was that whether the patient had freely and knowingly agreed to the treatment and held that valid consent must come voluntarily from the patient, not by assumption or by force or by deception. Now, who has the duty to obtain consent in medical practice? Medical personnel must obtain consent before treatment, but not in all cases that a consent must be expressly obtained. Now, let me just continue. Failure to obtain consent amounts to unlawful touch. Patient must have legal capacity to consent. For example, when you have a minor who has not attained the age of majority, it means that such a minor lacks the capacity to give consent. The same thing applies to somebody who is mentally challenged because his mental faculty is not optimal, it's not reasonable enough, it's not intelligible. It becomes very difficult for such a person to give a clear consent. So if its consent is given by a lunatic, for example, such a consent is invalid. The patients otherwise must come from, for example, those who are minor. That's what I was trying to say. Those who are minor or those who are incapacitated mentally, or so to speak. It does not mean that consent must not be taken or given before they are administered treatment to. However, such consent must come from whether the parents or the guardian. Now we have types of consent. Consent can be implied. So this is where I was saying that it is not in all cases. Consent can be expressed. Now, if consent is implied, it means that by the conduct of the patient, he or she has given consent to the medical practitioner to have contact with his or her body or to administer treatment. Let me give a very clear example. If a patient walks into a hospital and obtain his or her card and is referred to the medical doctor, and the medical doctor said, okay, I can see you have, I want to examine you maybe for something like fever or whatever. So if the patient now decided to, let's say the doctor now beckon him, lie on the couch, let me examine you. And without anything further, the patient climbs the couch and lies on it. Automatically, such a patient has given an implied consent. So such a patient cannot now turn around to say, I didn't give him consent for he to examine me in the course of treatment. Now, another kind of consent is express consent. In this regard, consent uh, must be given expressly. That is to say, there is no ambiguity as to whether consent is given or is not given. And these express consent usually have to be given when there is treatment of a radical nature, for example, in surgical cases. In that case, the healthcare professional has to obtain written consent from the patient. So, and these are for safeguards, either for the medical professional and even the patient as well. We know that surgical operation is always, accompanied with general anesthesia or partial anesthesia, if I will put it like that. But consent in whatever nature, in whatever kind of nature, regarding that kind of radical procedure, it is important that consent must be expressly given and a right. Now, there are situations where consent has to be specific. This means that if a patient gives consent, for example, for her right breast to be touched and examined, the medical professional does not have the right to proceed to the left breast and start examining the left breast also. So this is what we refer to as specific consent. Consent must relate to specific medical procedure. Patient must understand nature and type of procedure. Does not require consent to every minor step, however, because that will, hamstrung or rubbish the the free treatment of a patient. It doesn't mean that since there is what we call specific consent to be given for every single move or step the medical professional has to take concerning the patient, he has to be taking or obtaining consent. That's not what we are saying. But with with reasonable understanding, we do know that it is required that when consent is given specifically, it does not afford the healthcare professional to start going beyond that point and be harassing all parts of the patient's body. Now, legal implication of lack of consent. You see, absence of consent has serious legal implication because If consent is not given, definitely that will amount to assault and battery, like I explained before. If a medical professional decide to go ahead to start administering treatment for the body of a patient without consent, such will amount to assault and battery. And the medical professional can be liable for it if the patient decides to take a legal action against such professional. Consent is the foundation of medical law because it protects both the patients as well as what the healthcare professional. So in my subsequent video, I'll be talking about informed consent. But this is just a general introduction to understand that consent is a vital element as far as medical treatment is concerned. So, like I did say, if you are interested in this book, you can get in touch with me on WhatsApp +234 815 745 8711. Thank you and God bless.